What's going on there? Why do you have six cop cars on you?
We have a major police response in Kentucky when a father called 911 to report there was a naked man in his 13-year-old daughter's bedroom. The suspect, partially clothed, took off into the night, acted confused about why officers were surrounding him near a highway. We're going to dig into the details of this case, what we know about the suspect, and how police were able to locate him. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is another Law&Crime legal alert. So lawsuits allege that antacid use has been linked to increases in stomach cancer and gastric cancer. If you or a loved one were diagnosed with stomach cancer or gastric cancer after using an antacid, you may qualify for compensation. And one of our legal sponsors is partnering with the Driscoll firm, a national firm, helping those injured to ensure their claims are thoroughly presented. Visit antacidclaims.com/sidebar or scan the QR code on screen to answer less than 10 questions and check your eligibility to file a claim. Well, a father in Florence, Kentucky sure got a shock last week when he heard noises from his 13-year-old daughter's bedroom, opens the door, and what does he find? A naked man lying on the floor. Yeah, this happened on April 28th at around 12:30 in the morning. According to a press release from the Boone County Sheriff's Office, officers were originally dispatched for a shots fired call. You might be saying, how did this escalate into this? Well, the press release says that, quote, the victim's father stated that he awoke in the night and heard noises coming from his 13-year-old daughter's room. When he entered the room, he found an adult male lying naked on her bedroom floor. After telling the suspect that he was calling the police, the father went downstairs and retrieved a handgun. The suspect then pushed past the father and ran out the front door. The father ran out after the suspect as he fled on foot and fired 3 shots into the ground near the front porch of the residence. Okay, so before we go into the manhunt for the suspect, and we have some really good footage to show you as well, I want to bring in trial attorney Adante Pointer to talk more about this. Adante, so good to see you. First of all, this has to be every dad's worst nightmare, whether or not, as we'll talk about, it's, a guy who allegedly lied about his age because he had this romantic interest with a 13-year-old, or I don't know, just a random stranger coming into your daughter's bedroom in the middle of the night. This has to be every dad's worst nightmare.
It certainly is every dad's worst nightmare. Me being a dad, raising a daughter, a girl dad, certainly was on high alert during the teenage years. And one of the things that you just never want to be the person to walk in on, which is a grown man who has somehow snuck into your home, your sanctity, your sanctuary, and is in your daughter's bedroom. All you can see is red, and like him, you're going to get your handgun.
Legally speaking, let's take it from the beginning. Legally, would he have been justified to take out a weapon and use it at that point, to actually fire at this guy, allegedly? Is that legally justified?
Well, not just because the person's present in the home. There'd have to be, I think, some other aggravating factor. Person's threatening, doing something to his daughter, and or making moves that the dad perceived as a threat. I think that would then justify the use of some sort of force.
Because we talk about this in law school. Like the example of you take out the gun, there's a burglar in your residence. You can't automatically shoot them, right? You would think, oh, well, they're committing a crime. Not necessarily. There has to be some threat of imminent force, deadly force, a threat of imminent harm.
Exactly. In order for you to be able to use deadly force in self-defense, there must be defense of self or others. So the person who's in your home must be threatening, must be presenting some sort of act that's going to be, physically injurious. Essentially, they're going to hurt somebody is what
Right.
is what you have to see, and you'd be responding to that.
What about, just hypothetically speaking, it just got me thinking, if he sees the guy, or you see somebody in your home who's a burglar, and you take out a gun and you just point it at them, right? You point at them, leave my house right now. Would they be within their rights to do that?
I think that any homeowner is well within their rights. You come upon a stranger in your house in the middle of the night, you have a gun, you have a firearm, you certainly could point that firearm at that stranger, the person who's burglarized your home, broke into your home, and tell them to leave and warn them that if they continue or pose some type of threat, you're going to use deadly force. So I think you're well within your right as a homeowner to do that.
Okay, got it. So now what happens? So the suspect takes off into the night, and an investigation begins. Deputies from the Boone County Sheriff's Office, as well as officers from Florence Police, they started doing a canvass of the area, and they found this unoccupied car that was close to the girl's home. So what do? They look up the registration, and that led them to a driver's license for 20-year-old Parker Dean Kramer. And officers showed this photo to the dad, who confirmed that was the naked man in his house. So law enforcement, they fanned out around the neighborhood. They launched a drone, actually, to help with the search. And they provided us with aerial shots of what the drone saw as they took Kramer into custody a couple hours later. The arrest, by the way, was also captured on officer body cam. Let's take a look.
You may stop the question at any time by refusing to answer further or by requesting consult with your attorney. You understand your rights?
Yes, sir.
You want to talk to us?
Yeah. Where are you coming from? Dang, one, two, four, dang. What'd I do?
Why don't you tell us that?
I don't gotta tell you anything, that's what I do.
That's why I asked if you wanted to talk to us. You said, sure. Where are you coming from?
I have my lawyer.
Okay.
Can I call him?
At a later date, not right this second. Okay. Stick it back in the car. Thanks, gentlemen.
Sorry. I can tell you right here.
Alright.
Hold him real quick.
Why can I run? I got no fucking shoes on.
Alright.
I mean, I know people can run, but
Right, I got you.
no, I only got my phone. But I don't got my phone, but.
Is that gonna be our guy?
90, what can you do?
What's going on though? Why do you have 6 cop cars on me?
Alright, hop in.
Can I get it in the front of my hands?
Are you completely naked on my seats, I guess?
Yeah.
Alright. No.
I can't put it in the front?
No, you good? I could fit.
Hold on. I got a scar on my left.
Which one? Alright, get out now.
Which one grabbed the phone? Where was the phone at?
He had the phone.
Why is the 6 cop cars in?
Here, will you loosen that up for me? This left one.
Wait, what?
Again, you can answer some of the questions if you want.
Where's your clothes at?
You got that. It's on my right hand, the scar.
Well, your right hand's good.
No,
We're not,
my left.
you can loosen the left up a little bit. I don't care. He can do it, I guess. You gotta do it.
Alright, we're gonna go to my car. It's gonna be all the way on the end, okay?
I'll get those later from you.
So, as you heard there and saw there, while Kramer's wearing that sweatshirt, it seems he's forgotten his pants. Adante, what'd you take away from that police body cam video?
I'm sure that young man or that man was cold to be out there on the side of the highway on the interstate, middle of the night, surrounded, and he looked bewildered, almost surprised, although we know he knew he had an idea what was coming, given the fact that he fled so far from the house. To be surrounded by so many officers who were intrigued and questioning him about where he just came from, knowing darn well that he had just ran from that man's house and from this young girl that he was trying to hook up with.
Let me ask you this. As a defense attorney, is there a way to make sure that video doesn't come into evidence at a future trial? What would be some of the ways that you might be able to exclude it?
Well, some of the things that you would hope to try to use to exclude or to prevent that video from being played at a trial is through your pretrial motions in limine. You would say, hey, this is not relevant, or perhaps it's too inflammatory. The video in and of itself has low relevancy or probability to prove anything of a crime. And instead, if a juror were to see it, they might just convict him simply because they could see him sitting there naked on the side of the highway, being put into the cop car, or the fact that he invokes his Fifth Amendment right to a lawyer. Those are all things that a jury doesn't necessarily need to know or to see a video to be told. So those would be the things that I would do if I was his attorney in terms of attacking the evidence and trying to prevent it from being played in front of a jury.
The lack of pants, I think, is relevant to suggest where he just come from. And by the way, I might have misheard it, but I think he said he might have a scar. So in terms of identification, right, that could come up in testimony later on from, let's say, this alleged victim, has to take the stand as well, right? This, young girl, she can talk about, did you see a scar on his body, right? I think that might be relevant as well.
Absolutely. I mean, look, just because you're making an argument doesn't mean it's a winning argument.
Sure.
So the defense is going to argue, but I think the tape is coming in for a lot of those reasons that you've already mentioned. Identifying him, putting him at the place and the location, any other admissions that he may have made. Those are things, or the fact that he has no pants on. And the dad is going to say, hey, I saw a guy fleeing my house in the middle of the night with no pants on. And what do you know? We found someone in relatively close proximity with no pants on. That's the guy.
Yeah, it's a little different than my cousin Vinny with the same kind of car. It's not like, oh, there was another guy with no pants on, just happened to be there at the same time. Here's the thing. So Kramer, you could argue, seemed kind of cagey during his arrest, asking why he's been stopped, why there's so many officers. But according to the Boone County Sheriff's Office, when a detective interviewed him, he allegedly started to come clean. Kramer reportedly told the detective he drove from Louisville to Florence to meet this underage girl at her house. We checked, it's about an hour and a half drive or more. And Boone County Sheriff's Major Philip Ridgel told the Cincinnati Enquirer that Kramer told them he planned to, quote, wait them out in the tree line near I-75. By the way, real quick, Adante, the way they were able to apprehend him, so using a drone, going to finding the car, the license, the registration, really good police work.
Yeah, this is the state of affairs, or the state of technology, if you will, that policing is going into. Many departments are using drones. Many departments are using license plate readers. They're incorporating more technology into their police investigations in order to identify, detain, arrest, and convict people at a higher rate.
And by the way, quicker in time that you apprehend somebody, the stronger cases for the prosecution. Not as if, oh, we found this guy 5 days later. Well, are you sure it was the right person? What have they been up to? Close in time and close in proximity is important. Now, apparently, this investigator also says that Kramer allegedly admitted that he exchanged numbers with this 13-year-old girl, knowing full well her age. And he allegedly told her he was 15 and went to a nearby high school, which we know is not true. The detective who interviewed Kramer said that the 20-year-old, quote, made admissions which led to additional rape and sodomy charges. So yeah, Kramer was charged with 1 count of burglary in the second degree, 2 counts of rape in the second degree, and 1 count of sodomy in the second degree. He was booked into the Boone County Jail on a $250,000 bond. According to the Boone County Jail website, he's still locked up. The case has been bound over to the grand jury. Adante, let's talk about this. Before we even get into the charges for a second, that bond, do you think that bond's appropriate in a case like this?
Well, the bond is supposed to be to secure somebody's appearance and or to make sure that someone who's a threat to society is not going to be offending society or committing more crimes while they're out on a current pending charge. So, given what's alleged here, that he actually knew her age, that he, lied to her, told him that he was about her age, and then drove an hour in the middle of the night, broke into the home, and did whatever those allegations are that they're saying he engaged in. This is someone who I'm sure the judge is sitting there thinking to themselves, hey, am I going to be the person that's going to be at the top of that headline if this young man reoffends or does something? No, we're going to keep him right here in custody where we know he's at. the community is safe, and we're going to let the criminal justice system play itself out.
And that's the part of that I don't understand. If he allegedly admitted to a lot of this after saying he wanted a lawyer, there's a disconnect there. I mean, this is what the reporting indicates, but why would he have admitted this stuff or allegedly admitted this stuff?
Yeah, there's a lot of case studies and research that's been done. And frankly, for me, anecdotally, as in my experience as a criminal defense attorney and a trial attorney, there are a lot of people who initially invoked their rights to the Fifth Amendment against self-incrimination and said they want a lawyer. And that's out in the field typically. But then that growing sense of, I'm caught, they know what I did, maybe I can work a deal, maybe I can try to explain myself out of this position or predicament that I find myself, or better yet, maybe if I just, can talk about what happened in such a way, they might have some mercy on me or cut me some leniency. And so I tell you this, there's nothing more, I would think, terrifying than when you're brought into the police station or you're brought into the interrogation room or you're brought to the police cell and you hear the doors clang behind you. You know there's no way to get out other than if the police let you out. And the only way to get out at that point, some folks think, is by trying to kind of play themselves up to the police by admitting to what they did or explaining away their conduct.
Well, let's talk about that conduct, and let's see if he's going to be actually be sent to prison. Because according to Kentucky's criminal statute, what are these charges? 1, persons guilty of burglary in the second degree when with the intent to commit a crime, he or she knowingly enters or remains unlawfully in a dwelling. It's a Class C felony. Person is guilty of rape in the second degree when being 18 years old or more, he or she engages in sexual intercourse with another person less than 14 years old. Kramer faces 2 counts of second-degree rape there. And then there is second-degree sodomy, which is when being 18 years old or more, he or she engages in deviant sexual intercourse with another person less than 14 years old. Okay, so Adante, a few things here. 1, does it seem to you this is all stemming from one episode, not multiple episodes, one episode? And 2, how would the prosecution prove all this?
It's a little, without seeing the dates that they're attaching to each of these particular crimes, you're not quite sure just by the charges alone, whether or not this is one episode or one incident, or maybe this happened over the course of 2 different meetups that they may have had. However, we do know that he's charged with 2 counts of rape. So they're at least saying that there was some sexual penetration 2 times on 2 different occasions. It doesn't necessarily have to be 2 different days. They may charge him with if he did that on the same night but twice. So you're not quite sure. Nevertheless, in terms of evidence, certainly they're going to be doing what's called a SART exam on the young lady, on the girl, to get the physical evidence that they need in order to prove up that there was some type of sexual contact, DNA, and all that type of biological evidence that they'll get. They'll also have her testimony, which I'm sure would be pretty painful and gut-wrenching as she delivers a blow-by-blow account, if you will, of what took place, how she met him, what he said, how she was duped into believing that he was her peer versus an adult that, from the law's perspective, and I'm sure many people's perspective, was preying upon a child.
What is the defense here? What's the wiggle room for the defense? I mean, I don't think it's a mental health defense, because if you look at insanity, right, you may be saying, oh, he seems so out of it. No, mental disease or defect, he can't appreciate the criminality of his conduct, conform his behavior to the law, allegedly ran away, said he wanted a lawyer. Don't think mental illness is going to be a defense. So talk to me about what are possible defenses here, because you have to also imagine if this goes to trial within a year, 2 years, whatever it is, and you have this alleged victim taking the stand, what a difficult job it is for a defense attorney to cross-examine her.
Those are some of the most difficult examinations to engage in. You have someone who the jury is going to have a lot of compassion for, a lot of sympathy for, and maybe be predisposed to believe what they have to say. And yet you as a defense attorney are tasked with trying to undermine that person's credibility, perhaps attack their story, poke holes in their story, and try to impugn their character. And so that's a very hard tightrope to walk. I would say here as a defense, going back to one of the words my teenage kids use, they say, they're cooked. Look, when he himself admitted that he knew the young girl's age, he then told her he was 15 and they had been engaging in conversation back and forth from there. And then he drove and he broke in the house. I mean, at that point in time, he literally walked himself into jail and prison, given the type of consequences he's facing. Perhaps at sentencing, there's some mitigating factors that we're not aware of that might cut his prison sentence down. But from what we heard and the information we have at this point, it's not looking terribly optimistic for him.
Let's talk about the prison time or potential prison time if he's convicted or, pleads guilty. These are Class C felonies in Kentucky, and according to the state's sentencing guidelines, Class C felonies are punishable by 5 to 10 years in prison. Now, Adante, what do you think he would be looking at here? Would this be a case where, and we don't know a lot of the details of it, but we're just taking away from the charges in of themselves. Do you think a judge would look at this and say, you know what, this is going to be the max, going to be served consecutively? I think he should get, multiple decades in prison, or do you think it would be something on the lower side? I mean, you talked about mitigation, maybe his age. I don't know if that would help him, but talk to me about what we might be able to expect here.
Yeah, sure. The judge is going to have that decision to make. Does he run, or does he or she run the sentences consecutively, essentially stack them up? Every count's worth 5 years, 10 years. You're going 10 plus 10 plus 5 plus however many more, and then you get to some final amount as it relates to how much time he would be doing. Or they could run it concurrently, meaning, hey, there's 3 charges, they're all 5 years apiece. We're not going to give you 15, by adding 5 plus 5 plus 5. Instead, we'll give you 5 and run it all concurrently. That's a decision the judge would have to make. And you're right. The judge is going to be looking at aggravating and mitigating factors. His age may be one. Perhaps he has, as you mentioned, some type of mental defect. Perhaps, through his attorney and they're investigating, they are able to dig up some dirt on this 13-year-old, which would be pretty tough, I would think, to find given her age. But perhaps she's done this. Perhaps she's more sophisticated than her age might let on. Perhaps she understood his age. But there's a thing here in the law. She's too young to consent. So even if you bring those up as issues to bear for the defense attorney, I don't think that's going to get you very far.
And one other thing I'll add, I think it's actually in Kentucky, the jury may decide the sentence. They may recommend the sentence. I think it'll be up to the judge to actually impose it. But if that's interesting too, thinking about the dynamics of this case. I don't know if you've ever dealt with that before, but where a jury might recommend what the sentence is within a given range.
Right. Well, in some states, jurors do recommend sentences and or even select the sentence. So, that definitely can happen in a state like Kentucky. That's apparently the law. The question is going to be the way in which the jury has took in the information over the course of trial. Do they really believe this girl and what she says in her account of what happened? Are they sympathetic to this dad who walked in on a naked man in his daughter's bedroom after hearing noises and bumps in the night? Or do they look at this young man, the young man who's accused, and kind of, I don't want to say write it off, but look at it and say, hey, this young man he wasn't doing the right thing. We don't like it. Yes, it runs afoul of the law, but we're not ready to give him a lifelong scarlet letter by putting him in prison for 20, 30, 40 years and essentially taking his life from him. So those would be decisions the jury would make. And I bet it hinges on how they perceive his level of contrition and her level of engagement, but also the after effects in terms of PTSD or anything else that she might claim that she's suffering from.
And we always say this in so many of the cases we cover, these types of cases where you see this incentive for the prosecution to try to work out a plea deal so a jury doesn't have to hear about this evidence, the alleged victim doesn't have to testify, but it has to be attractive enough for the defendant to want to take it. Then again, thinking about what might be on the other side and going to trial, something that they'd be thinking about. According to court records, Parker's arraignment is scheduled for May 19th. We'll keep an eye out for this. Adante Pointer, thank you so much for taking the time. Great seeing you.
Good seeing you as well. Till next time.
And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.